All right, and we are live on YouTube. And let everybody who's coming in. Good evening, everyone. This is the Renters Alliance Renter Town Hall. Just getting started. Welcome, everybody. We'll get started in just a couple of minutes. Welcome.
Matt, you want to open up the chat?
Good idea. And we'll get started in just another couple of minutes. Wait for folks to get on. If you're just joining us, this is the Renters Alliance Renter Town Hall. We'll get started in just a moment. All right, I guess we'll get going. Good evening. My name is Matt Losack. I'm the co-founder, executive director of the Montgomery County Renters Alliance. We are awaiting the fire chief, Chief Corey Smedley, and some of his staff, but so far they're not here. So we're wondering if maybe they're attending to an emergency, which is, of course, very possible, and we hope not. Hope this is just a technical issue. But they may be unavailable to us this evening. But we have with us other special guests, which we're delighted to have. But first, let me say a few things about how we're going to conduct the evening. If you have any questions or concerns, please put them in the chat. We'll try to get to all of them before the end of the town hall. And if we don't, we'll follow up afterwards. I want to introduce my staff. But first, we have two special new staff that have just joined us. One is Max Wilberg, and the other is Brian Piat. They are graduates of Montgomery County High Schools, and they are members of the Westmore's Maryland Service Year program, and we're delighted to have them. They give us extra foot soldiers to deliver door-to-door information to tenants across Montgomery County and to assist our full-time staff. To begin with, that's David Mullins, our outreach director. And Emily Towie, our outreach coordinator, and Tim Wong, our outreach coordinator, and the person who is the mistress of our calendar and keeps us all organized, Malek Demir. But tonight we're going to discuss hopefully at least two topics, possibly three. As I say, we're waiting for the fire chief and his staff if he's able to join us. But we are also here to discuss what has become a chronic problem in many apartment communities and in anybody who's ever visited a commercial parking lot in Montgomery County, predatory towing. And with us this evening is the director of the Office of Consumer Protection, Eric Friedman, and his staff expert, David Ellswick, who will be discussing that. But a lot of people don't know what our Office of Consumer Protection does. So in just a moment, I'm going to turn it to the director, Eric Friedman, but I also want to say waiting in the wings is Nicole Catravanos, the manager of the Office of Landlord and Tenant Affairs. who will be providing her expertise about her office and code enforcement, and be able to answer any of the usual renter concerns and questions that come up week to week. So with that, I'll turn it over to Eric Friedman. Eric, welcome.
Hi there, and Matt, thank you so much, and Renters Alliance and your team for giving us the opportunity to share important message and information with all the residents of Montgomery County. You know, these meetings that you schedule are very helpful, and it's a great way to reach out, and we really appreciate it. You know, we're very fortunate in Montgomery County to have a local government consumer protection office that's been around for 53 years. We are a law enforcement agency. We have the power to issue civil citations for violation of the law. We can subpoena documents, and we handle complaints regarding almost any kind of dispute that you would have in the marketplace. We also, and the reason that we're here this evening, and we again appreciate it, is we also license all the towing firms in Montgomery County, and we set the rates. We handle all kinds of disputes of that nature. And we're also very fortunate to have Dave Ellswick with us. He has been in our office for about 2 years now. He is a certified master automotive technician, is certified in like every group you could ever imagine. And so he handles all our complaints regarding auto repairs, and also does our towing. We license a few different kinds of companies. We license all the auto repair shops in Montgomery County. We license all the new home builders. And we work closely with both the fire department and the Department of DHCA, Department of Housing and Community Affairs, landlord-tenant things. We all really work together. In Montgomery County government, we try to make sure that there are no silos. We really work together. So it's really very great, Matt, that you were able to bring all of us together. Let me just set the context and then turn it right over to Dave, if that's appropriate. We're here to talk about what's known as predatory towing. It's also called trespass towing or non-consensual towing. And it's been a problem and an issue and very difficult situation, as you say, Matt, for many, many years. Basically, the challenge is to get the right balance, because we can't have no rules in Montgomery County. But at the same time, this is not supposed to be a profit-making thing where tow trucks can come out, grab cars, hold them hostage, get money, and then do it again and do it again, hide behind bushes, do that kind of thing. That's not what we want, and that's not what we are allowed to merchants to do. And so there have been times when it's been really a major problem. That was back in about 2015 when it was at its highest in terms of problems. There was a $24 million class action lawsuit that was filed back in 2015. This issue, believe it or not, Matt, and everyone else who's listening, was featured on NBC Today's Show with a story. It was featured by ABC 2020. It's been reported in the New York Times, the Washington Post, even Kojo Namni. So it's up and down, and it's a constant challenge to get it resolved. We've got information on a website. We've got on YouTube as well. And what we're here to do is just to keep things going the way they should be. Some of these stories are unbelievable. I know you've heard them all before. And Dave's going to go through some of them. And let me just turn it over to him. And then I know, Matt, you may want to add some things, and certainly any questions we'll be here to work with.
Hello, I'm David Ellswick. I'm the towing investigator. I don't really have much to say. I don't really have many stories. There are a lot of stories though, but I mainly just have some tips and what to watch out for. My main tip is watch where you park your car. So in order for your car to be immediately towed, there has to be a sign pointing at the parking spot that you're parked in. That's supposed to be visible from every parking spot. So the best thing to avoid getting towed is make sure you watch where you parked at. I hear all the time that, my car's towed in the middle of the night. They only come when nobody's watching. It's extremely predatory. Surprisingly, those are the hours that towers are really only allowed to patrol lots. They're only allowed to patrol between 2 a.m. and 9 a.m. Outside of that, the property has to request in writing any kind of tow. So if you're towed outside of the hours of 2 a.m. to 9 a.m., you can actually request that writing from the property or the tower. They're both required to keep that the authorization for, any affected consumer to review at any time. So tow storage lots are required to remain open 24 hours a day, 7 days a week. You should never have any problem getting your car back if it's towed. If you can't reach the tower, please file a complaint with our office. I do get that occasionally. They towed my car, I can't get it back, nobody's answering the phone. If you have a valid handicap tag or a handicap placard, only a police officer can request your vehicle be towed. So one of the other biggest things is both the property and the tower are jointly liable for any violations of the towing code. So if the property tells you to deal with the tow company, they won't help you. Maybe they agree with you, but they don't have any say. They are actually just as responsible as the towers. A lot of times the properties don't even realize that they're responsible, but for everything the tower does, they're also just as liable.
So
That's pretty much
David,
it.
can I ask you, I want to backtrack on something because a couple of things you said are really important.
Yep.
And we've had lots of confusion over this. So it is our understanding, as you say, that the property owner or the property manager or landlord has to request in writing that the tow truck tow a vehicle that is not authorized to be there.
Right.
But between 2 and 9 a.m., you're saying that it's at the discretion of the tow truck driver or no?
That is correct.
So
So
that's, I thought there was a period where they weren't allowed to tow at all.
depends. There's two different ways to tow. So the majority of the tows happening are immediate tows. Your car's immediately towed. There's also a way that a property can tow. They can only have one sign at the entrance, but they have to put a sticker on your car and notify you 3 days in advance that you're going to be towed. So that's the only way they can immediately tell you, that there's a sign listing all the parking restrictions directly facing the parking space. All affected parking spaces have to have a sign visible, and that sign has to list all of the parking restrictions. So,
Well,
like I said,
so that we see. Most of the apartment communities have these signs that say they'll tell you for everything, including a smirk. But disturbing that it becomes the discretion of the tow truck driver. One property nearby had a number of cars towed between 2 and 6 a.m. and many of these people had paid for parking spaces and didn't know why they were being towed. And so it becomes, after a fact, that's when the tow truck drivers are patrolling in a predatory way, I would say. Eric, was there any movement to sort of bridle that somehow?
Well, the law has been changed and tweaked here and there. Again, it's a tough situation to get that right balance. We encourage consumers to be, as Dave said, to be very careful when they park to begin with. The rules are very complicated. There's a lot of rules, just tons of them. And if the towers don't follow every one, then we typically are able to get people their money back. The law also requires that somebody can file a complaint in district court and seek treble damages, 3 times the fee, if they have not done it properly. Things like, before they can tow the car, they've got to report it to the police, because we don't want the police to think that the car is stolen and start looking around for it when it turns out that it's just was been towed. So there are so many different requirements, and Dave's familiar with all of those. And we try our best to keep things moving smoothly. Unfortunately, there are a couple of towers that we would call predatory, meaning that they're here just thinking that the county is bounty hunting, where they can just look every time they catch a car, they get $170 or whatever the fees are. They sometimes act that they are the judge, jury, and jailer because the tower may decide that the violation exists. then they committed a violation, and then they decide that they hold the car hostage until payments are made. So it's constantly a struggle. There's no question about it. And Matt, the best we can do is just as you say, is to train people, explain things to people, make sure they report things to us. But there's never going to be a perfect way of resolving these complaints. But the more we can do to keep that balance, the better.
Okay, but just want to make sure we're clear on what we understand the rules are, that from 9 a.m. until 2 in the morning, any property owner, property manager, or landlord has to submit in writing a request to the tow company to tow. So that has to be sort of an action has to take place. It's not at the discretion of the tow truck driver. So that's important. So that covers two-thirds of the day.
Right.
Very disturbed about I thought in the past that they had come up with a law or part of the law that said that certain hours of the night, because it was so difficult for people at late hours to get their cars back, or it was dangerous for some people who might be towed late at night in parts of town, that they couldn't tow, unless, of course, the police ordered them to tow or some other emergency action. But is that blanketly true across the board, that between 2 and 9, wherever the tow truck driver can at his or her discretion take the car?
Well, they still have to comply with all the rules. There's no question about that. The only thing that's different during that midnight time period is that the property owner doesn't have to provide written request for that tow. But there's also the state of Maryland also has a statute regarding predatory towing or towing in general, which says that they can't just be trolling and doing things like that. So there is a difference between during that time period, but there's plenty of times when there are violations during that time period as well, and Dave will investigate that. And if we need to, we'll drive to the actual site to take a look at the signs to see if they're properly placed. Again, when you have a statute that says that a sign has to be readable or whatever, that becomes something that we have to evaluate as well. And Dave jumps on his car and drives around and takes and looks at some of these cases when he has to investigate them. And so there's always something. It's never a simple situation when cars get towed. I mean, there's even a drop fee if you walk there and see that the shop is just tying up your car and connecting it to getting it ready to be towed. There's a small fee that you would be able to provide that stops them from doing that. And you have to measure how much above the ground they had gotten away with doing. And a lot of times they don't tell the consumer that they could pay a very small fee if they catch them in the act of towing it before they actually tow it. So there's so many different rules, and Dave does a great job of going through everything, and we just want people to report it to us so we can take action.
Dave, is it a $25 fee for a drop fee? Is that what it is?
Yeah, $25 if the vehicle is over 6 inches off the ground. If the vehicle is under 6 inches, there is no charge.
So jump on the car.
I've had
Or
complaints
get me
like
to
that.
jump on the car and it'll come down at least 6 inches. Well, okay.
I also want to add very important about the written authorization. Somebody asked what is written authorization. It can be a text, email, actual paper form. But if I get a complaint and the tow happened outside of 2 a.m. to 9 a.m., the first thing I do is go to the property and request the authorization to see if it was actually authorized by the property. And then I request the authorization from the tower. They're both required to provide that to me, a police officer, or an affected consumer. So the consumers can do the same thing I'm doing, really. Did the property request it? Did the tower have a request? So anything outside of 2 a.m. to 9 a.m.
Well, it's obviously we've heard many stories where that's requested, and what do you know? Here comes the written request, and so it's sometimes a better idea to go to the requester and ask them to show you the request. And if they say they didn't make the request, what would you recommend the consumer do?
File a complaint with our office.
I'm just worried about in so doing, then, how would you gather evidence before you filed the complaint?
So pretty much all we would really need is the invoice from the tow. So with the invoice, I can get how much was paid, the actual reason the vehicle was towed, the address it was towed from. I can get the consumer's name, phone number, all kinds of information.
I'm just
So
wondering if you went to a property manager and the property manager said, I didn't authorize it, but you got to read the sign, which is of course not the law. And so it was towed out of the parking lot during the day. And you say, show me the authorization. And they said they didn't do it. Would you recommend that the person record the person saying, I didn't do it? Would you recommend that they sign something that says, no, I didn't do it, but you're supposed to? I mean, I'm just wondering about how to prevent the retroactive fabrication of an authorization.
yeah, that's a tough one. So there are times where there are bad actors. So I can say I've gone to properties and I've requested authorization and they didn't have any. And then I've requested the same authorization from the tower and they magically had it. But I mean, I usually go to the property first because the property doesn't really know a lot of the tow regulations. They depend on the tower to inform them what's going on.
Right.
And like I said, a lot of them don't know that they're jointly liable for these violations. So really it is the best practice to go to the property first, say, did you request this? And if they're willing to put it in writing, I doubt it, but it would be truly amazing. It would help me.
Well,
Or it
and
would help with a suit if you were going to file a suit.
of
You are
course, whoever
entitled.
you talk to, take down their name and their telephone number, so that you have that, or go with somebody else, so
Yeah.
that you have a witness that says that they denied that they had made the request. That would be important. Or if they suddenly create the request, to print it for you so you have a copy and it shows the date and time of when they actually created the request.
Yeah.
But I think it's very important to think like somebody going on Judge Judy when Judge Judy says, show me the evidence. And so one has to prepare in a smart way, knowing, unfortunately, as you point out, David, that, and that's the only time we're really concerned about this, is when there are bad actors. And when people are paying a lot of money, $150 or better, plus the inconvenience of your tow, to get their car back. Back to in the event that you come across someone towing your car, there's what is it? You said 6 inches, they got to drop it. Above that, it's $25.
Yeah. And if they leave
Okay.
the lot, then they're really required to take it all the way to the storage lot.
Okay, so if they leave the parking lot or the property where it's towed from, then they are authorized to take it all the way to their lot.
Yep.
Okay, and then the other thing is that if they're in the lot and they want to leave with your car, how do you stop them?
You can call the police. Hopefully they stop. I have had complaints where people have called the police on the tower. I've had people jump on the car, which I don't recommend as they drive away. But yeah, like you can take pictures just so that you can gather evidence and proof. I wouldn't put yourself in a dangerous situation. Take pictures,
Well,
call the
many of
police.
these tow truck drivers are full of grace and politeness, as you know.
I've never seen one.
My recommendation is that if they won't stop and they are not civil to you, to immediately begin videotaping,
Yeah.
so with your cell phone, and also, as I have done in at least one case that I brought with you guys, was I went up to the tow truck driver with my video on and asked him to show me the authorization, which he said he did not need at 3 o'clock in the afternoon. And that, case done. And we resolved that and got that poor man his money back from the tow truck driver. What else do we need to know?
Pretty much just watch where you park your car. But I mean, if you wanted to add on to that, so the second step I would do if I was requesting authorization is I would request the contract. The towing contract has to also be available for myself, a police officer, or any affected consumer that wants to see if the person that authorized it is actually able to do so. So anybody that requests a tow has to be designated in the tow contract. Like I said, that contract's available for any affected party. So that would be the second step I'd usually take. Do you have authorization? Do you have a contract? Is the person authorized to actually request a tow? So I've noticed in the chat somebody had questions about the signs. So the biggest thing about the signs is they're required to be 24 inches by 30 inches, and they have to list all the parking restrictions along with the name and the address of the tow company. They have to list the phone number of the tow company and certain other things. But in a parking lot with more than 45 spaces, there has to be one sign visible from every affected space. So if there's 45 spaces in a parking lot and it takes 3 signs so that you can see it from every space, then that's what's required. You don't necessarily have to have one sign on each and every space. It just has to be visible from that space. Sometimes in a parking lot with 45 spaces, it would usually take more than one sign. Yeah, and tenants are not usually authorized to tow a vehicle. There are
Right.
some people that have assigned parking spots, and they get there's one tow company that does this. They get special cards that prove they're the owner, has all the owner's information, their parking spot number, and in that contract it says any proven owner of a parking spot, something like that. So they would have to prove that they're the owner of that parking spot because they do pay for it every month. So a
So if
normal
you're in an
person,
assigned parking spot, that
yeah.
is your assigned parking spot, and you're towed from it because you didn't have, say, according to the tow truck driver, your decal or your thing hanging from your mirror, but you still are authorized to be there and that's your car. Is that an illegal tow?
Well, I guess it would depend on the sign. The sign of it. I mean, that's a scenario that I don't think about. But like I said, it would depend on if the property says you're required to have a parking permit or if you're not required to have a parking permit. Are you
I'm just
required to have?
thinking that if the property manager is the one who would have to say that you have let's say you have a permit because you're paying for that spot, and some people
Yeah.
are paying over $100 for a parking space, and they're in the assigned parking space. But say the property also requires that you have a decal on your windshield or something that hangs from your rear view mirror. And say for whatever reason that fell off, or you forgot to take down your handicap thing and forgot to put that back on, but you are in your correct space and it matches your license plate. And I've read hundreds, I'm sure you have too, of these signs that get put up, and they don't ever say anything about the decal or the thing on the rear view mirror. They always say being authorized to be here. They do say, your tags or your state of your vehicle or whatever. They go through the whole kitchen sink, but they don't usually say that you have to have whatever the unique requirement is of the property. They're sort of standard signs. Does that raise an eyebrow as a violation?
So if the property has on the signs that they require a parking permit and you don't have a parking permit, that would be a valid tow.
Right.
If you
But I
can't
have a
get
permit,
parking,
but I didn't put up the decal.
yeah. So there's no way for them to prove that you actually own the spot if you don't have that decal hanging or
Except the
visible.
license plate should match the spot.
Yeah, well, then you're relying on towers to run license plate numbers, and I don't think you would actually want that. I don't think towers have the ability to run license plate numbers to verify
So
ownership.
the tower's defense would be that you didn't have your decal, so I thought you weren't authorized.
Yep.
Okay. Very dispiriting, but good for the facts. The other thing is we see, and this is a general consumer affairs logic kind of thing, Eric, where we do see these signs that say everything but the kitchen sink authorizes a tow. And I'm wondering from a consumer affairs standpoint, from a landlord property, why would they care if my tag is expired, if I'm paying $120 for the parking space? And I'm going to get my tag done next week. I just haven't gotten around to it because I'm working or I'm not using my car right now, or I'm on vacation and my car don't need to do it till I get back. Why would the law allow for that kind of criteria?
Well, that's what gets to us, that the balancing act. What we want to have is a car being towed only if there's a parking problem, basically. That's the issue. You know, you talk about shopping centers where a car drives into a shopping center and they park there. And if in fact that fills up the lot and the customers can't go to the merchants working there or selling there, clearly that's not fair to the merchants. But when somebody goes into the shopping center and it's absolutely empty and they park there and they walk across the street to mail a letter in the mailbox, we don't want to have a towing company hiding in the bushes and come running out and tow the car away. That's not the intent of the law. There's no reason for that to happen. This is not a money-making situation for towers. That's not what it's designed to do. So, you know, Dave in our office has heard every crazy story that there is. You know, when you talk about the thing hanging there and it wasn't there, we have plenty of consumers who say it was there and that the tower took it down. And then took pictures of it without it being there. So trying to resolve these issues is amazing because there's always a story. But what we want to do is to make sure, the best of our ability, that towing is done when it's appropriate, when it's needed, and it's not designed to be a money maker, because these are weird contracts. Keep in mind, as you know well, Matt, these are very strange contracts that the towing company has with the property owner or the landlord. They sign a contract to do towing for zero, for nothing. You know, there's no other situation in the marketplace when a merchant and another merchant sign a contract for no payment. They basically say, we will sign a contract and we'll be the people that check on your property. It starts out as a very strange transaction to begin with. And so we try our best to have a law that keeps it in a manner that it's supposed to be used on. And one quick thing that I know Dave was going to talk about is if you have to pick up your car, it's got to be the impound lot has to be there open 24 hours a day. It has to be well lit. Sometimes, you know, Dave's gone out there and seen places that are so scary you wouldn't want to go back there. And that's not fair to consumers either, especially when they don't have proper lighting and scary places where they keep their cars in impound lots.
Eric or David, could either or both of you describe some of these things that have been fixed? I know that in the past, one of the things that you were a champion of, Eric, was getting rid of these spotters, getting rid of the kind of predatory towing that we were seeing. I know there was the famous video, I think people could see it on YouTube, of you are enforcing in one of the grocery store parking lots, spotters going around towing cars like crazy. They interviewed one person who said that he had nothing to do with it, but he was the owner of the tow truck company that was going about it. But in the past, you know, what was it that was going on with these spotters? And I'm assuming that with these zero contracts, that it would be illegal for a kickback for a property manager or landlord to get a piece of the action in predatory towing going on their property?
Well, Matt, you're absolutely right. And you also have a great memory. That is classic video what you just talking about, where the owner of the company on the camera says, I don't have anything to do with that towing company. And it turns out he was the owner. And that was the one that was part of this class action lawsuit. But it is pretty amazing that what we were able to change, as you say, was spotting. That was one of the worst things, where had towers literally hiding in bushes near where people park cars, and certain infractions, small ones, when a consumer was literally going across the street to get change or to get a donut or put something in a mailbox. And this is not what the state law and the county law allow. You cannot just be circling around. So that was an improvement that we were able to make several years ago. But it's always a difficult job for for David to investigate the complaints that we get. We keep track of them, and we're constantly trying to make improvements as best we can.
It would be great if down the road you're able to codify the principle of towing because it's needed, as opposed to towing at the discretion of the tow truck driver. That's a tough one. Yes,
Matt,
Emily, questions?
Yeah, sorry, we have a couple questions in the chat for Eric and David. If a tenant calls a tow company on another tenant between 9 a.m. and 2 a.m., is the written notification still required?
Yeah, so for one, unless that tenant is in the contract to authorize a tow, they can't authorize any tows.
Okay, so that's good. We're hearing complaints from one building where the property management is advertising because they have assigned parking spaces for tenants to call if to call this towing number if they see like their neighbor had parked in their spot. So you would advise to file complaint for these tenants. And then maybe guys, what is the best way to file a complaint with you? To go online, or how should people do that?
You can go online. It's super easy. It's probably a 5-minute process. Attach all the documents, any kind of written communication you have with the property or the tower.
Okay, thank you. And then we also had another question about how long someone what's the time limit to like make a claim if they were towed, and I guess in the situation you described would be a non-legal tow. If that happened 3 months ago, 6 months ago, and they had to pay a fee to get their car out, is there a time frame for filing a complaint?
Our statute of limitations is 1 year,
1 year.
so
Okay.
sometime before that.
Okay, thank you.
David, under what circumstances, if there is an illegal tow, is it authorized, I guess is the word, or possible to get treble damages? Under what conditions might a tenant have a greater success in getting compensated, not only with a return of the initial payment for the tow, but also for the inconvenience and for the violation?
So you would only be able to obtain that through civil process. You would have to file a suit. A lot of the time, I can tell the consumer that I can ask them to provide your money back and fix the violation. Most of the time that works. The tow company, maybe like Eric said, there are a lot of laws. Sometimes, that things do happen, mistakes happen. So I would ask them to refund the consumer and, cease the violation, repair the violation. I've had times where the consumer didn't want a refund. They just wanted me to take enforcement action. And I love that because that, for me, is the best way to stop a violation. And then they file a suit in court. They use the citation that I wrote as proof that this was an illegal violation, and they go from there.
So can you walk us through that a little bit more granularly? So say they want to do an enforcement. What does your enforcement actually look like? You do an investigation and you issue a written judgment, a citation. How does that work?
So I issue a citation for any violation is $1,000 fine. A lot of times, if a tower does one thing wrong, they're doing a lot of things wrong. And that kind of helps that case. Like I said, our main goal as the office is to make sure these things don't happen and to help consumers when they do happen. So, like I said, we're trying to help consumers and stop the violations from happening. A lot of times citations are not the best tool because it just creates an angry company from now on. But sometimes they are the best tool. So, I mean, it's just all discretion, honestly.
Well, I don't know too many tow truck drivers who are always happy, but
Yeah, I know.
so the citation, is that for a written fine, or is that simply some kind of a certificate? What does that look like?
It's a fine. It looks like a speeding ticket. It's $4,000, and I always include an abatement order. So an abatement order stipulates that they will cease the violation in the future, and if they are caught doing it again, it will be contempt of court. So every time I write a citation, I also include an abatement order so that just things never happen again. And if they do, it's a pretty serious issue.
So the $1,000, and then if they don't pay, or they say you're wrong, your investigation is wrong, then they can take you to court. But that $1,000, if successful from the citation, goes to the county. Is that correct?
That's correct.
Okay, so for the consumer to get their piece, they would have to then go to court.
Yep, they would have to file suit.
And in that suit, they could, obviously use as backup your judgment and citation, and then pursue treble damages. Have you seen that?
Occasionally,
And how do the courts tend to respond with you, especially in cases that look successful from your viewpoint?
to their individual suits.
Yeah, I mean, in your experience, when you filed a citation from a violating tow truck company and the tenant or the consumer pursues it in court, how do the courts react? Do you find them favorable to penalizing the tow truck driver?
Absolutely. So before I issue any citation, I gather a lot of evidence. I don't want to go to court with no proof or just allegations or he said, she said. So before I even go to court, I make sure that I have enough evidence to succeed. And
So
I'm
if
usually
somebody
not
were to
very hard.
bypass your investigation and your citation, you would of course recommend that they had all of their evidence as well. But then they would go to court and seek the return of the initial tow truck fee plus treble damages. And is that something that's usually best done with an attorney, or do you think they could do that in small claims?
I guess it would depend on their level of confidence. I've heard judges tell consumers they can do it alone, but they're going to make a lot of mistakes along the way. So just understand that. I mean, it's possible, but it can get complicated.
And maybe, David, do you know, or Eric, is this something that also could come with the attorney receiving court costs or attorney's fees?
I don't know.
Yeah, there's nothing in the law that provides attorney's fees. And Matt, as you probably know, in district court can really take a lot of time. So consumers have to determine whether it's worth their effort and time. You go to court, and then the case is continued. Someone doesn't show up, they reschedule it, things like that. So you've got to factor that in.
Mm-hmm. Well, we hope those who take tow truck drivers to court really have a good sense of revenge, which is a meal best eaten cold and slowly. Okay. Yes,
We have
Emily.
two more questions in the chat for you guys. Thank you for answering everything. Someone asked, is there a way to find out whether a property has an active contract with the towing company and what the terms are? I think you mentioned, David, that any affected consumer can just ask the property manager. Is that right?
That's correct. Any affected consumer. So you would have to have had your car towed to request a contract.
Okay. Thank you. And then we have another question. This person had a situation where they paid for the spot and it's required that you have like a decal showing it, and they didn't put it up one night, so they were still towed. But the question is, I'm not sure if you guys know, is it legal in the state of Maryland to drive with like a hanging tag on your rearview mirror? Because she said that's where theirs is required, but she thought maybe that wasn't legal, and so every night she like has to put it back up because she doesn't like to drive with it, and then she was towed from the spot she pays for.
Well, I mean, there are definitely certain places on the windshield that you have to have a permit. I'm not entirely sure about the hanging permit question.
Okay.
It would definitely be a distraction while driving, for sure.
Yeah, that's what they were saying, that it's a distraction for them, so they usually take it down when driving, put it up at night. One night she just didn't put it up and got towed from her paid spot. But okay, thank you.
Yeah, it is something down the road we might want to consider with landlord tenant, simply that we don't think that the consumer, at least from a tenant standpoint, is really properly informed about what the risks are of parking in a paid spot. And we also don't see the efficacy of towing for certain things that the property management should have no interest in. Again, a tag or occasional flat tire or something. We understand that there is a reasonable expectation by some property or landlords to have a car that doesn't look like it's up on blocks or being worked on or leaking oil in the garage or whatever, or creating an attractive nuisance, or some other issue with, keeping the good looks of the property by not having, awful looking cars in parking spaces, I guess, unless you've got something in writing that permits that. But generally speaking, all of us, if you haven't had a flat, if you haven't had a tag expire, if you've forgotten to put up your tag or your decal or whatever it is that they require, that to be towed is a very severe penalty. And it is just the worst thing if you're paying over $100, $150 for a parking space and you think your car is secure as it should be, and you find it not there in the morning on your way to work. And many of us have to be at work and can't be late. So it's quite something, quite not something, a casual bump in the night, but something actually quite serious. Any other questions for our experts?
Yeah, I linked I linked a site to what I thought was the Office of Consumer Protection site on towing. And I tried to click on the link, please use this link to access our complaint form, and it kind of gave me a like a down website. I'm not sure if I guess Emily
It looks like it's a disconnect, Eric.
I saw that too, but then I didn't know if this was the same form. If it scrolled further down, it says file consumer complaint. Is that the same, or is there a specific towing same one? Because one
Same
link
one.
wasn't working.
Mm-hmm.
Okay.
Yeah, the first complaint form. So something tomorrow morning, Eric.
We just redid our website like a week or two ago.
Yeah,
So that's good.
as Nicole knows, we're working on our website, and you have my sympathies. Okay, any other questions for the Director of the Office of Consumer Protection and the investigator, David Ellswick? If not, then first of all, I want to thank them sincerely for the work that they do. It's an important service to Montgomery County residents. Unfortunately, I think it's a service that many of our renters are still unaware of, so we'll do our best to inform them. Again, I think predatory towing is one of the worst things that happens to tenants on properties next to eviction. And we see, unfortunately, too much of it. So we'll do our best to get the information out. And unfortunately, Eric, we're going to have to ask you back probably down the road one more time to do this all over again. But one of the keys to public outreach is repeating ourselves. And so we're grateful for your service and for your dedication to consumer protection. And we want to thank you, David, for everything that you do to help make sure that towing at least is for practical and reasonable purposes and not abusive. So we thank you both for joining us. The fire chief is doing what the fire chief is supposed to be doing. Unfortunately, he is at an emergency, a traffic emergency, and we hope whoever was involved is unharmed or is at least receiving emergency services, as the Montgomery County Fire Department is dedicated to working on. So he will not be joining us tonight, but we do have with us Nicole Katravanos, who is the manager of the Office of Landlord and Tenant Affairs. And there she is, just dragging her away from her family to do this. But Nicole, we'll turn it over to you. I'm sure that there are many questions that people have, but you had some presentations you'd like to make up front. So Nicole, we turn it to you.
Thank you. Can everybody hear me okay? Sounds great. Good evening, everybody. It is 7:50. Just want to be aware of our time. Matt, please feel free to interrupt me at any point. Manager of the Office of Landlord Tenant Affairs, Department of Housing. As many of you know, we're here to serve landlords and tenants, to provide information regarding rights and obligations of both parties, to provide publications, manuals, answer questions through our 311 service requests. If you ever have a question and just want to speak with one of our investigators, We have a total of 9 investigators. They have a cumulative over 100 years of experience almost between all of them. All you have to do is call 311, ask to speak with our office, and I guarantee that you will get a phone call back within 48 hours. We also have a complaint mechanism. You can go online to our website and you can file a complaint with our office. We always encourage tenants to first address your dispute with your landlord. And if for some reason your landlord is not responsive or that's not fruitful, then you can file a complaint with us. And at that point, we will review the complaint so long as it's in our jurisdiction physically, meaning that it's not in Tacoma Park or the city of Gaithersburg or the city of Rockville. And so long as it's within the subject matter that we have jurisdiction over, then it will be assigned to an investigator, and an investigator will reach out to contact you to talk to both parties. And the role of that investigator is to be a neutral third party to investigate, to mediate, and then assist with determinations. And then there's always the possibility of a complaint going to the Commission of Landlord-Tenant Affairs. That said, about 97% of our complaints are resolved without having to go to the commission. So about 3% go to the commission. And at that point, the investigator drafts a case summary and the commission decides if they're going to have jurisdiction. And if they do take jurisdiction, then a hearing will be held virtually. And essentially whatever decision the Commission on Landlord-Tenant Affairs holds has the same weight as a judge in district court. And it is responsibility of the office to enforce that decision and order, and it can always be appealed to the circuit court as long as any damages is paid in a bond. So, quick summary of the work that we do and what we stand for and how we're here to assist the community. I thought that, I've been on these town halls a number of times, and I usually talk about the same subject matters that tenants tend to have questions about. But what I've never spoken about is the actual resources you can find online, both videos and literature. And I know that I myself personally, sometimes it's difficult for me to retain or absorb information when I'm being spoken to. And having a video that I can watch at home on my own time, or reading an article at home on my own time, allows me to process things a bit better and to see how it relates to whatever reality I'm living. So I thought I could make some use on sharing some resources online. And I've never done this before, so if somebody can guide me as to sharing the screen, I can share my screen.
I think what you do is you pull it up on, like you're showing it to yourself, and then you go to share screen, and you'll be because you're a co-host, you can share what you're watching.
Okay, and
just make sure all your personal photos of you on vacation in Brazil or wherever you were are not also on your home screen.
Okay, so I'm looking, would it be under more? Nope.
Should be on the
I
bottom.
see it. I found it. Okay. Let me know when you can see my screen, please.
There you go.
Okay. So this is a wonderful resource. Give me 1 second. I want to remove this from the top. I don't know how to. Oh, there you go. Okay. This is a wonderful resource. It is the Maryland Courts platform. We used to refer tenants to this when I worked at the District Court Help Center. And I got here it is, the People's Law Library of Maryland. Highly, highly recommend that everybody explore this website if you never have. You can see up here, it's at www.peoples-law.org, or you can just put in your Google search, the People's Law of Maryland. And if you scroll down, you can go by topic: consumer, criminal, domestic violence, education, employment, family law, and right here you have landlord tenant. So if you click on landlord tenant, they have a whole bunch of subjects: general, discrimination, ending a lease, evictions, for landlords, for tenants, leases, local laws, property conditions, public housing, rent court, and transfers. So for you to click here for tenants, they have a lot of very useful information. One of which I was exploring earlier today prior to this meeting is a checklist for renters. You click here. It guides you on things that you should be aware of prior to renting a unit. And it provides a checklist for you. I'll just skim the checklist, but it says it reminds you to read the lease carefully. It has you check what the rent is per month and also per week, so you can ensure that you can budget it. It talks about the security deposit, how much is required. As I'm sure all of you know at this point, as of October 1st, any leases for multifamily homes are limited to only 1 month security deposit with some exceptions. It has you go through any additional fees and costs. Make sure that you're fully aware if there's any utility fees, storage fees, recreational area fees, amenity fees, etc. As I'm sure many of you know now, with implementation of rent stabilization, if whatever property you're leasing is rent stabilized, then amenity fees are not lawful unless you're opting into them, right? So if they have a pool, you have the option to utilize the pool and then pay a fee, but you can't have a boilerplate amenity fee. And if you look through those fees, you can always contact the Office of Rent Stabilization, also via 311, to ensure that whatever fees are being proposed in your lease are lawful.
And let me just jump in, Nicole. Next
Sure.
town hall on the 23rd will feature the Office of Rent Stabilization, so we can get into that in more detail. So we'll put that in the newsletter, but they're coming. There's lots of questions for them.
Wonderful. Then it makes you go through your utilities. If you pay for utilities, is there a separate meter? What does it consist of? How are they allocating the costs? Then it talks about maintenance services. Is there a superintendent? Are there maintenance hours? Are there restrictions to those maintenance hours? How are emergency services handled? The law requires that the management company and owner provide you a phone number and a contact person for emergency services. It talks about laundry facilities, checking to make sure that they're in good working order, checking to see how many are available. And the recommended here is 10 washer and dryers. Well, 1 washer and dryer for every 10 apartments would be a good ratio. It discusses the lobby, that the tenant should take a walk through the lobby, see if it's clean, see if it's adequately lit. Does it have lockers or other security provisions? Do you have a doorman? What are the hours of the doorman? How are deliveries handled? There's a lot of properties now that, in an effort to reduce costs, have eliminated their doorman and have very limited delivery options. So whenever you are signing a new lease, it's always very important to have clarity on those aspects. Security when it comes to entrance and exit. Is there an elevator? Is it in good working condition? Are the stairs well lit? Are those in a safe condition? Are fire exits provided? What about sprinklers? So it goes through a whole list of things that, sometimes when you're in the hustle and bustle of a tenant to try to secure something superficially, something might look great. But if you take the time to actually go through these, it will either ensure that you're making the right choice for you, or it'll make you think of, reevaluating and looking at other options. And it continues with wiring, heating, air conditioning, windows, checking sure that they're all, they can all open if there's screens. And this is also important for your security deposit, right? Because sometimes tenants don't document everything on what the condition of the property was. And then 2 years later, or 4 years later, or 6 years later, the landlord may want to hold on to a portion of security deposit for certain repairs. And if your allegation is that that damage was there when I moved in, but you never documented it, it will put you in a big disadvantage when arguing that you're owed that security deposit back. So I highly recommend that you review this. I thought it was a wonderful tool. And this is one article out of all the articles here on the Maryland People's Law Library.
We will add this to our resources page on our website too, Nicole. You're right, it is excellent.
Yeah, absolutely. One thing to make a note is that these are Maryland. A lot of times they refer to Maryland's law, and sometimes county law, Montgomery County law and Maryland law doesn't 100% line up. So always double check to make sure that there aren't some county nuances that you may be missing.
Nicole, generally speaking, if Maryland law is stricter, it supersedes local law. Is
That is
that correct?
Yeah.
But not the other way around. What Nicole is saying is that if the state law is not as strong as Montgomery County's, double check with Montgomery County to see if you've got a greater protection.
Thank you. Another site here that's through the Maryland courts. If you go into this and just print escrow, maybe here, I don't remember where I got it, but I just pulled it here. There are these wonderful videos on rent escrow. The concept of rent escrow is a wonderful one, but I find that tenants often don't have clarity on how to implement it and how to use rent escrow. What happens often is that they have a condition in their property, it isn't repaired, and a tenant thinks that they can just hold on to their rent until that condition's repaired or until they have their day in court in front of a judge. And that's not how the law works. You have to file for rent escrow in court first. Once you have a hearing date, then you present to the judge what the conditions are of your unit. You explain to the judge that you've notified the landlord and provide documentation. You show that the landlord has not made the necessary repairs during that time. We always recommend that you contact code enforcement. So in addition to your documentation, you have documentation from code enforcement who's gone to the property and potentially issued a citation. And once you have your hearing date in court, at that point in time, if the judge approves, you can put your money into a rent escrow, but you can never and should never withhold your money on your own. So here are some wonderful videos on rent escrow that you can watch and, learn about the process. There's also a link to the actual complaint form that you can fill out. And there's, really helpful tips on rent escrow.
Nicole, could you just also quickly add what the escrow process is through code?
You mean what is the process to file a complaint with code enforcement for a maintenance issue?
There's the very famous process that the Renters Alliance put in place some years ago with Bill 1915, which was very valuable because, as you point out, the court process for rent escrow is kind of a bear for most people. And it is a difficult process. So the 1915 allowed for a tenant who had a chronic code violation, say a leaky faucet or running toilet or a broken appliance, and the landlord, and they filed a code complaint, and the code investigator cited the landlord, and the landlord still does not fix it, that with the permission or the authorization of the code inspector, the tenant could withhold up to a month's rent and pay for the damage themselves or deduct it from the rent. But that all had to be authorized by a code inspector.
Yes, that is the repair and deduct clause. And I can look it up online. There's a special process in order to do that through DHCA. So if you find yourself in that situation, if you don't want to go through the rent escrow process and you want to go through the Department of Housing, contact us via 311 and we can walk you through that process.
For anything, under a month's rent costs, it's a much easier process than having to go all the way through the court thing, which is extremely cumbersome for a lot of people. This is all very, very useful information. What else do we got out there?
Also, I'm assuming that you've already had, I don't know if you've had an update, Matt, on the landlord tenant state legislation that passed starting October 1st.
That sounds like a good one to tell us about.
Okay, so there's a lot of changes that's happened on the state level, which impacts all of us, and they all began implementation October 1st. One is what I mentioned earlier, security deposit. So if you live in a multifamily unit, and as long as you aren't currently qualified for utility assistance through the Department of Health and Human Services or the Department of Human Services, then your security deposit on your lease cannot be more than 1 month's rent. And this is for new leases starting October 1st. Also, the state has created a new Office of Tenant and Landlord Tenant Affairs. They're still hiring, so the positions haven't been staffed yet, but they have a website. They have a link where you can ask questions on the new law. So I highly encourage you to utilize that link if you have any questions and you want to reach out to them directly. They've been very responsive because I've reached out to them quite a few times. And they're in the process of creating a Maryland Tenants Bill of Rights. They're expecting the Maryland Tenant Bill of Rights to be out in January 2025. And once it's published, it's going to be required to be in all Montgomery County leases for multifamily properties. I know they're also making some changes to the right of first refusal for tenants. I'm not fully well versed on what that consists of, but I will be looking into that, and maybe at some point in the future we can discuss that again. Something that's very important for tenants, I know, is failure to pay rent actions and the ability to shield. So I know that there have been many situations where landlords have filed failure to pay rent actions against tenants in court. Sometimes they're valid, sometimes they're not. In situations where you've had a failure to pay rent action filed against you and you've had your day in court and your case was dismissed, meaning either the landlord withdrew it because you already paid it, or the judge dismissed it because you had paid it or because they weren't licensed, then your case will automatically be shielded within 60 days. Let me rephrase. It should automatically be shielded within 60 days. So if you've had your hearing date after October 1st on a failure to pay rent and a judgment was not entered against you, check online on Maryland Case Search and see after 60 days if your case is still on your record. If it is, for some reason, if they haven't automatically removed it, then I recommend that you go to the District Court Help Center and they can help you file paperwork to make sure it's removed because it should have been removed. And I'm sure at some point in the process, the courts will automate that system if they haven't already. Also for tenants who redeem the property, meaning they went to court on a failure to pay rent, a judgment was entered against them, but prior to the actual eviction date, they were able to pay the rent owed and they were able to pay to stay. Those judgments can also be shielded, but the catch is you have to wait 12 months from the date that you receive the judgment. So, make a note on your calendar if that's your situation. If you're able to pay to stay, make a note 12 months after your judgment date. You can go to the courts and you can file to get that shielded from your record and it'll be removed.
Nicole, is it shielded or expunged?
Shielded. Expunging is for criminal records.
So shielding means, what does that mean exactly?
It's just kind of a different terminology and a different process. Expungement relates to criminal records. Shielding and sealing relates to civil records.
Okay, so shielding meaning it's still there someplace, just the public can't see it.
That's correct.
Okay.
Yeah.
I like expungement better.
But expungement is just for criminal proceedings, so, and they're different forms and whatnot.
Understood.
Also, these are small administrative procedural changes, but previously, after a landlord received a judgment of possession on any kind of case, whether it's a failure to pay rent or a tenant holding over or a breach of lease, they could automatically file for a warrant restitution 4 days later. Now they've changed the law. They have to wait 7 business days to
Wow.
file for a warrant of restitution.
That's good to know. That'll affect all of us in terms of what we do.
Exactly.
Nicole, sorry to be tedious, but just so everybody knows, failure to pay rent is what it sounds like. If you don't pay your rent, the landlord could sue you for eviction until you pay your rent, and if you don't, you'll be evicted. Tenant holding over is that you've been told that the end of the lease, whatever that date is, if you stay 1 day longer than that, you can be sued for eviction for tenant holding over. And for a breach of lease is any kind of violation of the rules of the lease. So if you're making too much noise or you're committing crimes or breaking the rules that you've agreed to on the property, that's called breach of lease. Those are the 3 most common ways that people can be evicted, the most common being failure to pay rent. But those are the 3 ways in which people can be evicted. And the other was wrongful detainer, which means you weren't supposed to be there in the first place. You're not on the lease. Basically, you're a squatter. That's pretty rare, but that happens too.
Thank you, Matt. And the last thing, which I think Montgomery County Sheriffs were doing anyway, but they formalized it via state law, is that evictions cannot be executed when there are extreme weather conditions. So a temperature of 32 degrees Fahrenheit or lower, a winter storm warning or a blizzard, etc., or excessive heat warnings. I think that the sheriffs in Montgomery County were doing that anyway, but now it has been formalized via state legislation.
Nicole, forgive me for not knowing, but did they pass a law yet on the putting persons' evicted belongings in storage as a requirement? Has that happened?
No, it's not even proposed yet. I know there were council members that I'm aware. There were council members that were discussing that, but I don't think it's been submitted to council.
I believe in Washington, D.C., there is a law that says if you're going to be evicted and the landlord is putting your stuff out, that they have to put it in a safe place or storage place for several days so that you might have more time to recover your belongings. It's sort of an act of decency. And I believe it's under discussion in Montgomery County Council, as Nicole points out. What else have we got? Anything else from you, Nicole, in terms of your overview?
Just wanted to remind everybody that we now have an Office of Rent Stabilization. And so if you have any questions regarding rent increases, regardless if your property is subject or not subject to the rent stabilization law. If you have any questions regarding fees, when you call 311, ask for the Office of Rent Stabilization. They are now handling everything that has to do with fees and rent increases, with a few exceptions.
All right, and again, they will be on our next town hall on October 23rd. It is 8:15. We have a few more minutes. We like to cover one thing that's already been covered, thankfully. We have Nicole Catravana, so we know what the Office of Landlord and Tenant Affairs does. Can you quickly describe for us and remind us the differences between code and landlord-tenant in terms of your obligations?
Sure, absolutely. Code enforcement is an office within our department. Whenever you're having any type of maintenance issues, whether it's a leaky faucet, whether it's a broken window, whether it's an issue with mold, infestation, you have to think code enforcement. And they're very efficient. All you have to do is either you can go online or you can call 311, ask for the Office of Code Enforcement, let them know what your maintenance concern is. We always ask tenants to first address their maintenance concern with the management company or with the owner. And if they do not remedy within a reasonable time, which usually is 30 days, if it's not an emergency, then contact the Office of Code Enforcement. They will then reach out and they'll have an inspector go inspect the property. And if there's any violations on code enforcement, then they will inform you, inform the landlord, and based on the urgency, they will give the landlord a certain period of time to remedy that violation. If the landlord doesn't remedy the violation during that time period, and if the landlord doesn't give a justifiable good reason, then the inspector will typically issue a citation. Those citations run about $500 every citation, and they can take them to court for that as well. That also puts the tenant in a situation where they can file for rent escrow in court. They can reach out to our office for a repair and deduct form or process if they're interested as well. If you decide to file rent escrow in court, the benefit of that is that the judge has a lot of flexibility in what they can grant you. They can say you're going to put your money into a rent escrow account, but when you have your hearing date, depending how egregious the situation is, the judge could give you all your money back, or they can allow you to hold on to a portion of the rent and have a reduced rent for the time period that you had to reside in the unit with reduced services. Or they can allow you to get out of your lease. And if you're in a 2-year lease and you have a rodent infestation that's really bad and it's been going on for months and it can't be taken care of, a judge can let you get out of your lease without a termination, damage or clause or penalty. So that is one good thing about rent escrow. It's more of a process, but you also have more flexibility as to, what you can do if you want to leave your lease, if you want to end your lease, or if you want some monies back. And there is a district court help center on the 2nd floor of the Rockville District Court that can actually help you in person to fill out those forms with an attorney and that can guide you. Then anything else that's not maintenance related goes to the Office of Landlord Tenant Affairs. So if you ended your lease and you didn't get a notice within 45 days of why your security deposit wasn't returned, or only a portion of your security deposit was returned, and you believe that deductions are not valid, it's one example. You can file a complaint with our office. Another example is, we have so many.
We only have a few minutes, so don't worry. Just give
Okay.
us a couple.
We have issues sometimes with parking. If there is a reduction of service within the entire building, a permanent reduction of service, that is something that we can look into. If you believe there's any terms of your lease that are unlawful, we can review your lease. If you received a notice to not renew your lease, and you believe that notice is unlawful, or you believe that notice is retaliatory, you can file with us. I will always say that retaliatory cases are challenging cases. They're not black and white. There are a lot of conditions to be able to exercise a retaliatory defense. And what some of those conditions are that at the time that you received the notice, you were current on your rent. And that you should have, as a tenant, exercised a right, and within 6 months of exercising that right, you received a notice to vacate. So just a few things to take into consideration when it comes to retaliatory defenses, but our office has determined retaliatory actions in certain situations. And in other situations, things aren't very clear cut. We usually are able to mediate. We recently have a case open that we just almost completed mediation, where a tenant filed for code enforcement, filed a complaint with code enforcement, within a month's time received a notice to vacate, but she hadn't paid rent. But the landlord was unlicensed. And then the landlord was alleging that they were having a family member move into the property. and they provided documentation that the family member was moving. So it was not a clear-cut case. Our office wasn't in a position to say this is clearly retaliatory, but there was good arguments on both sides. And the options were either let's mediate this, let's see if we can get an extension of your stay in the unit for another 6 to 9 months, or take it to district court. And if you take it to district court, it's up to the judge to decide if they're gonna, accept the defense. And if they don't, the tenant would have received an order of possession at worst. And at best, they would have said, okay, 6 more months, you have 6 months until you can give her another notice to not renew. And we are in the process of negotiating 9 months. So it was a win for the tenant and for the landlord, because then they didn't have to go to court and they didn't have to deal with the legal expenses and the time. But it wasn't an easy case, and there were very strong opinions on both sides. So
Well, if you decide to move on from DHCA, we've got a job for you as a correspondent on Court TV. So you'll do just fine. You don't have to address this now, but food for thought for when we talk later. The 6 months thing was a state law, but I think Montgomery County's code says retaliation under any circumstances at any time is against county code. Whereas I think the state law had a 6 month sort of a grace period that you couldn't do anything for 6 months, but after 6 months, the landlord could go after you. So I think there was some confusion about. I've heard from lawyers from Public Justice and other places that said Montgomery County's anti-retaliation code is stronger. I hope that's true. We'll look into it and get back to everybody who's listening.
to be continued.
In any case, Nicole, you're an expert. We're so glad to hear, and we're glad you're heading the Office of Landlord and Tenant Affairs. We will, of course, I'm warning you now, ask you back many times again, because our community needs to hear this information over and over again. And of course, some people are new to the renter community and also need to just hear it for the first time. We have just a few minutes left. One of the great pieces of advice that we give to anybody forming a tenants association is to start on time and end on time. So with that in mind, Emily, quickly tell us what we do with regard to tenants associations.
Sure. So we're always happy to help tenants organize. If you're in an apartment community, and you're it could be that you're having issues there and you want to know what your resources are, or it could be that everything's great and you just want to get together with your neighbors and just be well-informed tenants. So it doesn't have to form out of animosity with the property manager, although often they do. It's not a requirement. So even if you don't know your neighbors, but you'd like to start something, you can reach out to us at our email or phone number, which we'll put in the chat. We'll help you set up a first meeting. We can print and distribute flyers to invite all your neighbors to come to the building. We'll host a first meeting where we'll give kind of a crash course on what the best practices are for a tenants association, what to do, what not to do. And then we're also available for individual casework if there's like widespread issues, like everyone's receiving rent increases, everyone has broken appliances, we can deal with those as an association. But if you're having a specific situation just between you and the landlord, something in your lease, we can look at that and then connect you to Nicole's office or to code or to some of the free lawyers that are available through Maryland Legal Services Corporation.
Great. And Tim, tell us about the access to counsel and evictions work.
Yeah, so if you want legal advice for free, you can call 211. They're the Homeless Persons Representation Project, who has been looking for lawyers, has finally hired a lawyer, and so they're back online. So the best way to reach them is to call 211, and they will direct you to either the Maryland Legal Aid, CASA, or the Homeless Persons Representation Project. So if you're facing eviction and you want them to walk you through the process or have any legal questions about that, you can ask them, and you can try asking them about other legal issues, but I think a lot of times they will represent kind of eviction cases. So yeah, feel free to reach out if you have any questions. And they could represent you if you meet the income qualifications. But you know, if you make too much, then they could give you legal advice, but they might not represent you in court.
Yeah, the Access to Counsel and Evictions program was funded just in the last couple of years by the state legislature because we recognize that the vast majority of tenants who go to court are not represented by an attorney. And the vast majority of people who go to court for evictions are low-income tenants. So there is an eligibility requirement. I think it's under $50,000 or about $50,000 a year, but it depends on the size of your family and other criteria. But we can guide you through that process. And obviously, we urge everyone who has to go to court to go to court. Don't miss your court date. And if you're facing eviction, again, as Tim says, there are 3 resources in Montgomery County: the Homeless Persons Representation Project, Casa de Maryland, and Maryland Legal Aid. And the 211 can connect you to that. But if you have any questions about whether this is a good idea for you, whether there's something you could do before you have to go to court, you can always contact us. We have put in the chat our info@rentersalliance.org. You can email us, or our fancy 888 number. Where is that? 888-668-7717. So you can also contact us and we will get back to you in short order. So are there any other questions for Nicole Catravano? So for us, staff, that you've been monitoring the chat?
There's one comment. I saw some questions regarding HOC properties. And we do get a lot of complaints that involve HOC vouchers or HOC properties. And I'd like to clarify what Ulta's role is with HOC vouchers and HOC properties. We can ensure that HOC properties are compliant with Chapter 29 and with code enforcement. We can also ensure that any property that receives an HOC voucher is compliant with 29 and code enforcement. However, we do not supervise or ensure that HOC staff are properly handling their cases, or what their internal processes are. Sometimes we get complaints from tenants saying that the HOC hasn't been, receptive with a recertification. Unfortunately, we're not involved with that. There is an HOC liaison that we can refer to, but we don't supervise their work and their internal processes.
The Housing Opportunities Commission is an independent organization. And while we work with them collaboratively, as does DHCA, they are independent. They receive the majority of their funding from the National Health and Housing and Urban Development Department. And so it is something that's different, but we work with them all the time. And the Renters Alliance works with them all the time on some of these similar issues. So if you have an issue with HOC, you can contact us and we can help navigate with investigators, with case managers, and with the leadership of HOC from time to time. I will say that thanks to a collaboration with DHCA and with the director, Scott Bruton, we've been having more and more conversations with HOC about how to improve services and deal with some of the inefficiencies that have been identified by the tenants receiving those services. So it's on our agenda. It's on HOC's agenda. We had a lovely meeting with Chelsea Andrews, the new executive director, and for the first time in a long time, whether it's DHCA, HOC, even the county council, and of course our county executive, Mark Elrich, we have people who are receptive to the issues that renters are facing and interested in secure, affordable, quality housing. So with that, I want to thank again Nicole Catrovanos. I want to thank our guests, the Director of the Office of Consumer Protection, Eric Friedman, his expert on towing, David Ellswick. Again, I'm sorry that the fire chief and his team were not able to join us, but they were doing what they must do, which is to help out in an emergency, and we will have them back at a future town hall. Our next town hall is Wednesday, October 23rd, same bat time, same bat channel. And we will have the Office of Rent Stabilization on next time. So with that,